Thank you, Mr. President. I beg to move that a bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Mr. President, I am very privileged and pleased to appear before you in this honorable House today to speak to the Administration of Justice Indictable Proceedings Amendment Bill 2024, which was passed with an amendment in the other place on Monday, the 13th of May, 2024. Mr. President, we have long spoken of preliminary inquiries, which have long been recognized as a bottleneck in our justice system. In March 2023, prior to the proclamation of the Administration of Justice Indictable Proceedings Act 2011, also known as AJIPA, nearly 38,000 indictable matters languished in our district courts. In point of fact, Mr. President, even as we stand here today, there are matters still at the stage of preliminary inquiry in our courts which are in existence for in excess of 13 years and have not yet reached the stage of indictment. Mr. President, in appreciating the amendment which is before the House today to further the objective of AJIPA, we have to appreciate that the relief which AJIPA is intended to bring and is bringing represents cases which not only affect the individual accused, but also affect the victims, their families, and the communities who are all waiting for closure and justice in outstanding matters. This government, Mr. President, took the decisive step to finally abolish the antiquated pretrial procedure of preliminary inquiries that plagued our justice system. For the first time in our history, a novel, efficient, and electronic approach to pretrial proceedings has been established. The abolition of preliminary inquiries, Mr. President, is one of the major reform initiatives undertaken by this government that works in tandem with several other reforms and demonstrates our commitment to achieving swift and fair justice for all through a comprehensive overhaul of the criminal justice system. To name a few, Mr. President, we have seen the establishment of specialized court divisions, the introduction of judge-alone trials, the decriminalization of certain road traffic offenses, new plea bargaining legislation, the establishment of a public defender system, and significant resources consistently applied to the justice sector to improve its plant, its machinery, and its processes. The long-awaited abolition of preliminary inquiries through AJIPA complements these significant reforms. What is also of enormous importance, Mr. President, in the 10 years since we have been moving through the enactment of AJIPA and finally bringing it home, is the continued involvement of all parties in the process. The government has actively engaged key stakeholders for the past 12 years in order to continue to gather feedback and to refine our approach to the abolition of preliminary inquiries and the implementation of a more efficient pretrial mechanism. In June last year, 2023, I stood before this Honourable House to introduce the Administration of Justice Indictable Proceedings Amendment Act 2023, Act number 12 of 2023, which provided, Mr. President, for, among other things, the enforcement of electronic filing, which reduces the archaic paper-based systems, the requirement for early filing of the indictment, as this has been identified as a source of delay in plea agreements as well, stricter timelines for compliance by all parties to the proceedings, the elimination of the requirement of cross-examination and additional oral evidence, steering pretrial indictable matters out of the district courts, formerly called magistrates' courts, placing pretrial indictable matters before the masters of the High Court in the criminal division, thereby allowing for earlier identification of matters to be tried summarily, ensuring case readiness through the introduction of timelines and scheduling orders, and effectively allowing for the sufficiency of the evidence to be determined through an assessment of documentary evidence as opposed to the laborious eliciting of oral evidence and the many years of cross-examination that has plagued this system in the pre-trial preliminary inquiry process. Mr. President, in talking about the consultation which this government has been engaging in and continues to engage in, our stakeholders have included but are not limited to the Judiciary of Trinidad and Tobago, the Trinidad and Tobago Police Service, the Office of the Director of Public Prosecutions, the Public Defender's Department of the Legal Aid and Advisory System Authority, the Trinidad and Tobago Prison Service, the Law Association of Trinidad and Tobago, among others. Mr. President, in that process of consultation, as recently as December 2023, the Judiciary of Trinidad and Tobago, in collaboration with the Office of the Attorney General and Ministry of Legal Affairs, embarked on a sensitization program for stakeholders in the criminal justice system on a JIPA and the systems and processes contained therein. During those sessions, the judiciary demonstrated the new electronic filing systems for initiating indictable matters before the High Court through the novel web portals using case lines and case center software for all evidential uploads, evidential management, and case presentations. I am pleased also, Mr. President, to inform this House that the groundbreaking impact of the proclamation of a JIPA has been coupled with the newly introduced Criminal Procedure Rules of 2023, which has continued with a JIPA to move forward the swift administration of justice. Very significantly, Mr. President, and we spend a lot of time in this place and in the other place talking about the independence of the different arms of the state, the judiciary, the executive, and the legislature. And very significantly, as we move to look at the bill that we are here to debate today, we have had a very recent example of a concept of our separation of powers that is least spoken to, the interoperability of the separate arms of the state, the legislature, the cabinet, and the judiciary. What do I mean by that? We have brought a JIPA, the cabinet, the executive, to this parliament. The parliament, in its two houses, have given the opportunity to parliamentarians to debate and to refine a JIPA and to pass it into law. And then the judiciary, in the interoperability of which I speak, in progressing and advancing our society, takes the baton from there and begins to implement. So as recently as January of this year, Mr. President, in the case of the state against Sheldon Dudnath, which was published by the judiciary in a media release on the 1st of May, we learned of a decision which is being presided over by Madam Justice Lisa Ramsume-Hines. That case was filed, and the dates are significant when we think back to the 13-year-old delay in preliminary inquiries, which has been eliminated by a JIPA. The case was filed on January 11th, 2024, with alleged offenses including kidnapping and larceny of a motor vehicle. The sufficiency hearing, the process by which all of the evidence to take the case to the stage of an indictable commitment at the assizes, which is now in documented form, no cross-examination. The sufficiency hearing was concluded by the judge on April 16, 2024, with the accused being committed to stand trial before the San Fernando Assizes. 4 months, Mr. President, in place of the perennial wait of 6 to 8 years, sometimes amounting to 13 years, to move a case from the summary trial before the magistrate to the indictment before the assizes. So we have the remarkable situation in 2024 in which a case 4 months after the accused was charged, the pre-trial proceedings commenced, The initial and sufficiency hearings were completed. The master committed the accused to stand trial. The accused appeared before a High Court judge for trial, and the presiding judge now indicates that she anticipates that the case will be completed before the end of July, a mere 6 months after the filing of the indictment. Let me repeat that, Mr. President. The judge has indicated that the case is expected to be completed a mere 6 months after the filing, after the charge of the accused before the first instance court. That, Mr. President, is what a JIPA has brought to this country through the efforts of this government. Coupled with a JIPA has been introduced, as I have said earlier, the Criminal Procedure Rules 2023. And among the things that the Criminal Procedure Rules has brought into effect is the Case Progression Officer. Cases are now being managed by the judges through the Case Progression Officer. So when we read the order of the court, the judge who has moved the case already through 4 months and is expecting to manage the case to completion by by July of this year, we see that one of the orders that the judge has pronounced on is to say that no deadlines and no timetables fixed by her order may be altered by the agreement of the prosecuting and defense counsel without her permission. So you're not allowed, as lawyers managing the case, to take the case away from the charge and trial conduct of the trial judge. If you want any extensions, you have to come back to the judge and justify it. That is how we are going to move the system forward. And that is how, under the new JIPA process and the criminal procedure rules, the court is now driving the process to ensure that persons get a fair trial in an expedited period of time. What the criminal procedure rules, Mr. President, 2023, which are in tandem with a JIPA highlight, is that there is now a responsibility on attorneys to advance the case without using court hearings to do things, and parties can manage themselves, allowing precious court resources not to be wasted. Madam Justice Ramsuhe Hines expressed the objective of resolving non-capital indictable matters within a year and capital indictments within 2 years. This is the progress that we are speaking to as we look at the bill that is before us today. And may I indicate, Mr. President, in looking, before I turn to the clauses of the bill that we are looking at today, that we are here today to move an amendment, 2 short amendments to 1 clause of a JIPA, Section 21, because in the continuing stakeholder consultation that all citizens and entities of this country are committed to, the Office of the Attorney General and Ministry of Legal Affairs received correspondence from attorneys representing the Board of Inland Revenue, attorneys representing the Director of Public Prosecutions, the Public Defender's Department, and the Police Complaints Authority. And it is they who, as they see the process of a JIPA working its way through the system, have brought to our attention some of the teething problems that are being experienced by what is new legislation, and have asked us to come back to this House for the few amendments that we wish to introduce today. So if I can now turn to the substantive provisions of the bill which is presently before the House, Mr. President. Clause 1 provides, as we'd expect for the short title, Administration of Justice Indictable Proceedings Amendment Act 2024. Clause 2 deals with interpretation. It clarifies that throughout the bill, the Act refers to the Administration of Justice Indictable Proceedings Act and ensures consistency and understanding of terminology within the legislation. It provides for clear titles and nomenclature throughout. Clause 3 constitutes a substantive provision of this bill. Mr. President, the current Section 21 of the bill of a JIPA was circulated, as I've said, for wide stakeholder comment prior to proclamation. And what we are introducing at Clause 21(1)(a) is to provide that witness statements must be signed by original statement recorded by the police officer or by the witness. The first proposed amendment to this section involves the insertion of a new subsection 9, which would incorporate the definition of police officer as outlined in the Proceeds of Crime Act, Mr. President, which is borrowed. So we are borrowing from the Proceeds of Crime Act an enlarged definition of police officer to ensure that the prosecution can commence with parties who play a role in the initiation of proceedings who are not exclusively police officers. So subsection 9, clause 3b, is to insert after subsection 8 the new subsection 9. For purposes of this section, police officer means an officer of the Trinidad and Tobago Police Service and includes an officer of the Customs and Excise Division, an officer of the Board of Inland Revenue, or any other officer of an agency of the state lawfully vested with investigative powers similar to those exercisable by a police officer appointed under the Police Service Act. That's the first substantive and the main amendment that we seek to introduce by clause 3 in the bill before this August House. Additionally, Mr. President, we wish to amend, and this is indicated at clause 3, section 21, in subsection 2, in paragraph A, by inserting after the words police officer or the word given, so that this enables acceptance of statements provided by witnesses directly or recorded by authorized persons other than police officers within the strict definition of police officers. Mr. President, as I said before, those amendments have been brought to this House, and I pay tribute to them by the very worthwhile contributing enhancement of the process from correspondence from the Board of Inland Revenue, the public defenders, the Director of Public Prosecutions, and the Police Complaints Authority. It is important, Mr. President, and I signal this to this House, it is important to appreciate that we continue to engage in our stakeholder consultation so that we have continued to we've issued correspondence, my office, on the 26th of March 2024 to key stakeholders requesting feedback on other issues facing the implementation of AGIPA since its proclamation. Some stakeholders have responded, and I thank them for their respective submissions. We await feedback from others, and it is very likely that we will be coming back before the other place and this House for some further enhancements of the legislation as we refine it by way of amendment. And if I may just mention one or two other things as I close, Mr. Speaker. That process of stakeholder engagement includes our international partners, so that my office is in collaboration with the United Nations Development Programme through the Peace Justice Project, which aligns with this government's focus on addressing case backlogs, aiming to integrate software, hardware, and capacity interventions to mitigate current and to prevent future challenges in the criminal justice system. This project is intended to deliver improvements to court and case management systems, modernization of procedures, deployment of information and communication technology, training of police, prosecutors, judges, and court staff, and enhanced coordination across the justice sector. Even as I speak, Mr. President, a first batch of equipment has already been delivered through the efforts and the collaboration of UNDP to the Office of the Director of Public Prosecutions and the Trinidad and Tobago Police Service. AGIPA, Mr. President, represents a pivotal milestone in our ongoing quest to improve our administration of justice and to provide for a more effective and efficient judicial system. Just as technology advances at a rapid pace, Mr. President, so too must our approach in delivering justice. We cannot afford to be complacent in the face of mounting caseloads and lengthy delays. The AGIPA is not just a piece of legislation. It is a strategy to modernize our justice system, to deliver swifter and more effective justice. All stakeholders are playing their part, and I applaud them and I thank them. And with that, Mr. President, I beg to move.
Mr. President.